All right, and we also have Ivy, the Secretary of State. Anybody present on that?
I'm here, sir, but I haven't seen Dan.
Okay. Okay, we'll pass the case then. And anybody here on, is Kimberly Stone present yet or no? It's a little early for that. All right, well, let's go off the record for a minute. All right, that'll bring us to People v. Noah Hansen. It's file 25-7107FH. All right, and we've got the prosecuting attorney, Ms. Goodrich. We've got Mr. Gilbert for the defense present. We're here for an arraignment and also a show cause. So on the arraignment, Mr. Gilbert, you had a chance to review the charging document?
Yes, Mr. Hanson and I have gone through the charging documents. He knows what he's been charged with and wishes to waive the reading.
All right, well, under a plea of not guilty on the charge of assault with intent to do great bodily harm and reckless driving causing serious impairment. Is the forensic center referral requested?
It is not.
All right, and estimated length of trial?
I'm going to leave this one up to the prosecutor.
I think one day.
Mr. Hanson, it's alleged that you're in contempt of court for positive drug tests while you've been on bond. You've got the right to have a hearing about those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of a lawyer and to present evidence in your own defense. If you are found to be in contempt, I could jail you for up to 93 days or fine you up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond. Do you understand the rights that you have and the penalties that you could face? Mr. Gilbert, do you know how he wishes to proceed about that?
Yes, we'd like to ask for a hearing at this time.
We'll schedule this for a docket call on February 10 at 2:40 in the afternoon. And we'll also schedule that for a status conference on the pending contempt or bond violation at the same time. But given the number of positive tests, I'd like to hear from counsel about whether I should continue or cancel Mr. Hansen's bond. Ms. Goodrich?
Your Honor, he had 2 prior violations in district court. It was a no contact violation on September 25th with a co-defendant, and then an increase in the THC creatinine ratio on November 3rd. So here we are again now with positive drug screens. So I would ask that the bond be revoked at this time.
Mr. Gilbert?
Your Honor, I point out that my client's adamant to me that he's not using. He was around some people that were using. I'd point out that the drug screens I saw did increase on the second drug screen, but now we're dropping. And I would ask that the court, if we continue to monitor or put him on a short leash where if they spike again, that his bond's automatically revoked. My hope is that, and my plan is that by the time we get to February 10th, that those numbers will have decreased off and I can put testimony on that it was a secondhand that made that increase. He did admit to using down in district court, but tells me that he hasn't used since. I'd also point out that I believe he's on a second interview for a very good job with Mueller Aerospace over in the Petoskey area. And I know they are very adamant about testing their employees for drugs. So if that's a continuing thing, that would be a job option that would not work out for him. So my request would be not to revoke bond at this time, but if there is an increase, that it be revoked at that time.
Yeah, I don't know, Mr. Hansen, this is a really serious crime. It's alleged that you've participated in where somebody could have been hurt or killed, and you seem to just blow off your bond conditions. I think I smell marijuana on you from here. I'm canceling your bond right now. Be remanded to the custody sheriff until further order report. Right, I've got somebody appearing on Zoom video and see who they are. That'll bring us then to People v. Courtney Self, file 25-7089 FH. And Mr. Gilbert, we're here for a docket call, and we also have a show cause. What's our status on the docket call?
The prosecutor has provided me with a plea, and I provided that to my client. And also, however, when talking with my client, she has informed me that she's intending to retain counsel. So she would like an opportunity to do that.
Okay. And Ms. Self, it's alleged that you are in contempt of court for violating conditions of your bond by not calling and not testing. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt, the right to the assistance of a lawyer, and to present evidence in your own defense. If you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond at any time. Do you understand the rights that you have and the maximum penalties that you can face?
Yes, Your Honor.
Mr. Gilbert, how she wish to plead that?
She would like to request a hearing at this time, Your Honor.
We'll enter a plea of not guilty to contempt. We're going to schedule this for a docket call and a status conference on the pending violations on February 3rd at 1:30 in the afternoon. Then you going to have an attorney by then?
I should join.
And I guess given that Ms. Self just seems determined to not comply with testing at all, I'd like to hear from both sides about what I ought to do about that thing.
Your Honor, bond is set because it's a privilege and there's conditions to given in order to not be incarcerated, and she has chosen not to follow those conditions. So I'd ask that her bond be revoked.
Mr. Gilbert?
Well, Your Honor, I think we're here on these two instances, 11-18 and 12-1. I don't believe that there's been any, unless I'm incorrect, there's been any violation since the beginning of December. My client has supplied me with a few documents. I've just received these. That one does look like there was a test on 11-18, and it looks like Harbor Hall was closed on 12-1. So I haven't presented these to the prosecutor. Again, I just received these. However, it looks like there might be a defense to some portions, if not all. So I would ask the court to maintain bond, and if she violates hereafter, then revoke at that time.
Myself, I mean, there's the show causes that we've got, and I don't want to tell me anything about those, but then see, just the report shows plenty of days that you're not even picking up the phone to call. 11-27, 11-28, 11-29, 11-30, 12-6, 12-7, 11-22, 11-23. You don't get to do that.
Your Honor, I check in on.
I don't want you to tell me about it. I'm going to tell you this. I'm not going to cancel your bond today. One missed call, one missed test. I don't care. Sunday you're calling. Every day I get one report that shows any problem in this. I will sign a warrant. We won't have any other hearing until you're arrested.
Absolutely, Your Honor.
And you'll sit for the whole case. Okay, you have to comply with this. This is not optional. You don't get to decide when you comply. You understand me?
Yes, Your Honor.
All right. That's your only warning from me. All right, so I'll continue bonds this time. Yes. All right, do we need Mr. Colton from the jail, or does council want to approach him? Or, well,
We can approach.
okay.
By the end of this hearing, the message is unmistakable. Bond is a privilege, not a right. Between drug test violations and a pattern of noncompliance, the court chose custody over risk. In a separate moment with another defendant, the judge reinforces the same principle. Miss one call, one test, and the consequences escalate immediately. These rulings reflect a broader judicial priority: accountability before sympathy, especially when public safety is at stake. Cases like this remind us that courtroom leniency has limits. If you found this case as eye-opening as we did, hit like, share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.